Deputy Registrar, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, hearing of appeal in CCJ Appeal GYCV number 7 of 2021 between the Commissioner of the Guyana Geology and Mines Commission and the Diamond Quarries Incorporated and Baraca Quarry Incorporated. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rochnut-Lee.
Good morning, Counsel.
And Mr. Justice Burgess.
Good morning, Counsel.
May we have the appearances, please? Thank you.
May it please your honors, my name is Comm'r Ramkaran, and I appear in association with Harry Ramkaran, Senior Counsel, for the appellant, the Commissioner of the Guyana Geology and Mines Commission.
Yes. Good morning.
Good morning, Your Honors. If you please, I am Tim Jonas, and I am led by Mr. Edward Locku, and with us is Miss Eleanor Locku, or the respondent, Diamond Quarry, Inc.
Yes, good morning again, Mr. Jonas. Mr. Ramkaran, are you ready to begin?
Good morning, Your Honors. I'm Harry Ramkaran, and I'd like to thank Your Honors for the opportunity to address Your Honors in this matter and to indicate that with your permission, I'll be sharing my time with Mr. Comm'r Ramkaran to address Your Honors on particular matters relating to law. Your Honors, the issue, I rely fully on my written submissions, the initial written submissions and my submissions in reply, which contain all my arguments in full. We would be unable to deal with all of these issues, so wherever we omit, the written submissions are there. Your Honors, but I would like to take the opportunity that has been granted to us to highlight some aspects of this case and to stress what we believe to be the important aspects. Your Honors, the issue of the subdivision, the alleged subdivision of the land for which Diamond Quarries had applied looms large in this case. The motion itself seeks an order of certiorari to quash the subdivision. The applicant on behalf of Diamond Quarries, do not Samaru, in his affidavit alleges that the subdivision was grossly unfair. It was based on mala fides, favoritism, it's highly irregular, abuse or misuse of public law powers, executive lawlessness, unconstitutional, illegal, arbitrary, capricious, procedurally improper, denial of legitimate expectation. Your Honor, not to be outdone, if that is not a mouthful, in his submissions made on behalf of Diamond Quarry, the GGMC is accused of mala fides, revisionism, disingenuousness, and prevarication in alleging that in denying that there was a subdivision. Your Honors, I will not go into the evidence, the detailed evidence. It's all set out in our arguments to show and demonstrate that no decision was ever made by the GGMC to subdivide the land in question. What in fact happened was that there was a discovery after the application and the advertisement in the official gazette, which was a significant step in the proceedings, that Baraca had made an application for the identical portion of land in 2006 and had occupied all or part of it for quite a considerable period. A GGMC then called a meeting at which Diamond Quarry and Baraca Quarry were present and proposed a subdivision. Immediately upon the proposal of that, as a compromise, immediately upon the proposal of that subdivision, they wrote to the parties, and Diamond Quarry replied in 2 days and disagreed with the subdivision. Diamond Quarry, do not Samaru, in his letter, confirmed in his letter of reply, the 16th of February 2015, confirmed that this was a compromise proposal. So, and the report which was tendered by Do Not Samaru, Exhibit C, stated that this was a compromise proposal. So at all material times, the parties were ad idem on the issue of this being a compromise proposal. Within 1 month, Your Honors, within 1 month, on the 11th of March, the letter was dated the 14th of March. The GGMC's letter, I think, was dated the 14th of February, offering a subdivision as a compromise. On the 11th of March, before GGMC had any opportunity to consider anything, this motion was filed. So there was no subdivision.
Mr. Ramkaran.
Yes, Your Honor.
May I just inquire, I follow you fully that your argument is that the commission did not decide on a subdivision. But could I ask you, is that not one of the objectives of these proceedings, that you want to engage in a subdivision of the area applied for by Diamond?
No, Your Honors.
Okay.
The objective of our proceeding is to have the matter considered by GGMC. Under Section 88 of the Act, it has the power to grant a license, discretion whether to grant a license or not, upon all the conditions being satisfied for the application. And then it has a discretion. It may grant a license, a quarry license. All we're asking for is for GGMC to have the opportunity to do so. And the orders made by Chief Justice Chan and the Court of Appeal is an obstruction to GGMC considering that the application. If I may step ahead a little bit, Your Honors. The Court of Appeal set aside the mandamus order directing GGMC to grant a quarry license to Diamond. But the Court of Appeal left in place the order of prohibition, prohibiting GGMC from offering the land to anyone else, to any other body or to any other body, person or body. So GGMC is fettered in the exercise of its discretion. One, it's fettered by an order of court, which orders it not to subdivide, which it never did. But it is also fettered by the order of prohibition. So the court has, at the end of the day, when GGMC comes to consider all the implications of this case and all the facts and all the circumstances which have arisen before and after the advertisement in the Gazette, GGMC cannot exercise the discretion. It can reject Diamond Quarry's application. It has no power to subdivide under the Act. It can accept the application or reject it, having regard to all the circumstances that we have before us.
But Mr. Ramkaran, why would GGMC not want to give the license to Diamond?
Well, the issues that have to be considered before it can give the license to Diamond is that in 2000, according to the evidence, not Baraca's evidence, GGMC's evidence, Baraca applied for the same land in 2006. That's one. Secondly, Baraca has been occupying the land. But if you look at the evidence of Baraca, leave aside for the moment whether that evidence can be properly taken into consideration on the merits, Baraca has presented, has tendered an advertisement in the official gazette, a notice of intention to grant it a license in 2006. So there's legitimacy to its claim.
Or okay, I want to interrupt you right if I may. That is the point that is troubling me. Baraca are not here.
No,
maybe they have abandoned their interest, because you cannot advance Baraca's interests. You are a commission that is supposed to be neutral and not favoring the interests of any particular body. Baraca knows of these proceedings. Perhaps they're no longer interested. So why is the commission getting exercised about the interests that Baraca might have in these lands? They are fully aware of these proceedings. They're not here to promote their own interests. So it seems to me that the commission does not have to take those interests into account anymore.
Well, if I may depart from Your Honor on what the commission can do. Your Honor, the commission has before it, at the moment before these proceedings were filed, it had before it evidence or information that Baraca had been occupying these lands, that Baraca had applied for in 2006 for the same lands, and that the lands were not, and that application was pending, and they were trying to resolve this matter. That is the point at which this case was filed. And those are the interests that Baraca has to consider. It is true that Baraca has abandoned its interest in the proceedings, but GGMC is not absolved from when the time comes for it to consider, to discard the knowledge that it has within its breast that Baraca had applied for these lands in 2006.
Mr. Ramkaran, on that question of the application in 2006, you say it is for the identical land for which Diamond applied?
Exhibit C says so, Your Honor. GGMC says so.
Yeah.
And well, I don't want to rely on Baraca's evidence, because that's a matter in issue before Your Honor. But Baraca also says so. But the critical fact is that GGMC is saying that it is the same land.
Yes. So is that the one in respect of which it's alleged that there was a mistake in terms of the coordinates that were applied for?
Baraca says that there is a mistake, Your Honor. Baraca says so, not GGMC.
I see. In relation to that application as well, is it true that the GGMC have followed up with Baraca and asked for additional documents and indicated that in the absence of receipt of those additional documents, the application will be regarded as having fallen by the way? There was, I gather, some correspondence from Baraca to the commission asking for some clarification, and then there was nothing further. So what would be the status in those circumstances of the 2006 application?
Well, Your Honor, there is no evidence that GGMC actually discarded Baraca's application. As a matter of fact, Exhibit C, which is a report compiled in 2015 when the discussions were going on between GGMC, Diamond Quarry, and so on. GGMC made a report and said that Baraca has applied for the same land in 2006. So at that time, it clearly appears that GGMC considered that the application was in existence. The application had not been discarded in 2015.
So, Mr. Ramkaran, in respect of what lands was the cease to work order issued in 2014 then?
Your Honor, the land which Baraca was occupying on which GGMC, there's a little conflict here, Your Honor, which I must draw to your attention. Donald Singh in his affidavit said that the land applied for by Diamond was the land occupied by Baraca. Later on in his affidavit, he said that the land Diamond Quarry applied for was partly occupied by Baraca. Baraca, in Rahman's affidavit, Ashik Rahman, on behalf of Baraca, said that the land, that the application by Diamond Quarries is for the land that I am occupying. So it seemed the preponderance of evidence suggests that the land that Diamond Quarry had applied for, was the land that Baraca had been occupying. Your Honor, I must point out also two things. One,
Mr. Ramkaran, before you go further, so the cease to work order was made against Baraca on what basis then?
on the basis that Baraca had been occupying lands without a license. Your Honor, two things I'd like to point out, stress. Under Section 44(1) of the mining regulations, which is the section that requires the advertisement to be made in the official gazette, that same section concludes that upon the advertisement, the applicant is considered to be in occupation of the lands, is deemed to be.
Could you take us to that section again, Mr. Ramkaran, please?
Section 44(1) of the Section 44(1) of the mining regulations. Your Honor, it's contained in my submissions at paragraph 2.13. I've set it out there.
And do you have the page number?
The page number is 374, please, Your Honor. And it says, Your Honor, if you'll permit me to read it, it's not long. Before any concession or lease is granted, the Commissioner shall publish a notice in the Gazette for 3 consecutive Saturdays of the intention to grant such concession or lease, and the area comprised within the application shall be deemed to be lawfully occupied from the date of such notice. So we have a situation here, Your Honor, where the land was published in 2006 for Baraca. Notice of intention to grant a lease was published for Baraca in 2006, and that is contained in the affidavit of Ashik Rahman. That That would be, Your Honor, at page 112. That would be at page 112 of the record. So Baraca is lawfully entitled to occupy the land, and Diamond Quarry is lawfully entitled to occupy the land because a notice of intention was published for Diamond Quarry as well. So that's the situation which GGMC needs to resolve. The second aspect, Your Honor, is contained in the affidavit of Ashik Rahman, several paragraphs. He sets out details of his occupation of the land, the occupation in relation to the infrastructure, buildings, which office buildings, housing buildings for housing, and buildings for machinery and equipment. Your Honor, paragraph 70 of the mining regulations, which are also contained in my submissions, provides that the holder of a provides that a person can utilize.
Just tell us where you're reading from, please.
I'm fine. I'm looking for it, Your Honor.
Thank you.
It's contained in my submissions. It's contained in my submissions in reply, Your Honor. That would be a page. I beg your pardon. That would be at page 853. It's paragraph 9.5. And it reads, Your Honor, it's not long. The Commissioner may, on such terms and conditions as he thinks fit, permit any holder of a claim to occupy a portion of state land in the vicinity of his claim for the purpose of erecting thereon a residence for himself or persons in his employ, or any mill or any work or building required for mining purposes, or for any business or legitimate object. Connected with mining, provided such land is not required for mining purposes or the occupation thereof, and so on. So Baraca was occupying land for this purpose. So it's a legitimate occupation. So GGMC would be entitled to have the opportunity to consider this legitimate activity of Baraca prior to any decision that may have been made. And Your Honor, for these reasons, I would respectfully submit that Baraca's situation cannot be discarded merely because Baraca did not appear in this appeal.
Baraca, that's, as you could see, that's the issue that seriously troubles me, because not only did they not appear in this appeal, but it seemed as though they ignored the notices that were filed and did not seem to put forward their interests as and when they could and should have.
Well, Your Honor, I can't answer for Baraca, but my position is I'm looking at GGMC's interests, and GGMC is faced with the situation of an occupation by Baraca of these lands, which might be partially legitimate. It was based on advertisement, which gave them the right to occupy, and it was based on the construction of infrastructure, which they're entitled to do, even if they don't have a license for that land.
Mr. Ramkaran, you are saying that the notice of intention of 2006 deals with the same land as the notice of intention of 16th of September 2014.
GGMC asserts that, Your Honor. Yes.
Yeah, but I'm comparing them now. At first sight, it doesn't seem to be the same area. It's a mouthful, but it doesn't seem to be exactly the same area. So we need to get some better explanation there.
Your Honor, Your Honors, the particular set out in the notices of intention are not identical. I, however, have to advise Your Honor that I am not in a position to explain the differences in the coordinates. It's something that I am beyond my capacity to understand or determine. So I just skim it over and just leave it like that.
Yeah, but you are making the point that it's the same area.
Well, I'm saying my client is saying so, Your Honor. I'm relying on what my client is saying.
Okay, well, we'll see what the other side is saying, and then we can see if we can.
My client is saying so, and Baraca is saying so, and Diamond and Samaru says nothing at all. Samaru says nothing at all about that aspect.
I thought Baraca was saying that they used the wrong coordinates.
Baraca did say that a mistake was made.
Yeah.
He did say that. Yes, Your Honor.
And of course, well, Mr. Samaru said that he made all his checks, and Mr. Singh acknowledged that in the documents that are kept by GGMC, there was no indication whatsoever that this particular area would not be available for a license. That's why he got it. So at least you could speak of some maladministration.
Well, I was wondering when that was coming. That is so, Your Honor. There is no explanation for this, for GGMC's laxity in this aspect. Your Honor, Baraca had a license, and it's in the evidence of Ashik Rahman since 1974, and Donald Singh in his affidavit said so, that Baraca had been quarrying for about 50 years. Ashik Rahman had a license, and from what one can gather from his affidavit, he wanted to extend his, he had a license, and he wanted to extend, he had a license, and he doesn't say that he's been occupying land without a license. He doesn't say that, but Samaru says that, and I have to rely on the evidence of my own witness. Samaru
and Mr. Singh says that. Isn't
sorry,
that so?
Sorry, Your Honor. Thank you, Your Honor. Donald Singh says so.
Yeah.
So that Baraca apparently was quarrying on land for which it had a license and on land for which it did not have a license.
No, it had a license for, as I understand it, they had a license for some part of Monkey Jump.
Yes, Your Honor.
But they were quarrying on an area of Monkey Jump where there was no license for them.
That seems to be the situation.
That seems to be the case.
So the 1974 license that Baraca had, it does not relate to the area for which Diamond applied.
It does not appear so, Your Honor, but Baraca doesn't say so. It doesn't appear so. And
but you representing the commission.
GGMC, Your Honor. What Donald Singh says is that Baraca was occupying part of the land for which Diamond applied for.
Yes, but the 74 application, which was granted, Was it in relation to any of the lands that Diamond applied for?
It does not appear so, Your Honor.
Okay, good.
Based on the evidence of my witness,
Good.
GMC's witness. Your Honors,
And Diamond and Baraca was never granted any license to quarry in the area for which Diamond applied.
no,
Do you agree?
I agree with that.
Okay.
I agree with that. And if there is any area covered by the advertisement which was made in 2006, then Baraca would have been occupying that area lawfully.
Yes, I understand. And of course, there's a dispute about whether, as my brother said, we're talking about the same property.
Yes, sir.
But there is I'd asked you earlier about the correspondence between the commission and Baraca in relation to the 2006 application. And since I found the letter I had in mind, I wanted to take you to it and just get your reaction. This letter is at page 116 of the record. And it is written to Rahman, the managing director of Baraca, by a representative of the commission. Do you have it there, Mr. Ramkaran?
I have it here, Your Honor. Thank you very much.
I refer to your application for quarry license dated June 26, 2006, situated in the Monkey Jump area, and wish to advise you that you have until September 17, 2008 to finalize all issues pertaining to the issuance of a said quarry license. Failure to comply will result in rescission of the notice of intention to grant, and your application will be recorded as abandoned. Now,
I am aware of that letter. Yeah.
Wonderful.
Have it before
so can you say whether all the issues pertaining to the issuance of the license were resolved by Baraca?
Well, Baraca replied to that letter 2 days later, Your Honor. Well, a month later, a few days less a month, on the next page.
Right.
And he said your letter, and this was in 2008, September 2008. Remember, his application was in 2006.
Yeah.
And he asked for some clarification in relation to the letter of August the 20th. He sought some clarification. I won't read the whole letter. Said the deadline was unfair, and so on. And then he sought some clarification, and that appears to have been the end of that episode. That appears to be the end of that episode. Nothing further happened until Baraca then took up the matter later on with Minister Robert Passad at page 121, and the evidence, and there's some other evidence that he took it up with Minister Robeson Ben, who was commissioner at that shortly after, during that period. So Baraca pursued the matter.
Yes, and you're saying, sorry to interrupt. Sorry, you said in response earlier to what I'd asked you, that even after this period of time, the commission still regarded the application as operative.
I would so submit, Your Honor, and I respectfully submit that the evidence for that is the engagement of the commission with Baraca's application in 2015, when it wrote to Diamond Quarry, in 2014, I think, when it wrote to Diamond Quarry and said, look, we have an existing application in 2006.
Wouldn't it, when Mr. Samaru was making his checks with the GGMC to see if he could possibly apply for a license, wouldn't that have been the moment that GGMC had told them, listen, we have an earlier application, but nothing was said. So he did all his work, and they said, well, there's no objection. And so he filed his application and he paid his fee and he complied with all the other conditions, according to the evidence, also of Mr. Singh.
Your
so
Honor,
that would have been the moment that GGMC could have said, listen, wait a moment, there is a problem here, we cannot do this or whatever, but they had no information. They said, yes, it's all right, it's available. You file your application, and then the notice of intention was even published. And then it was then that somehow Baraca woke up, and GGMC said, oh, we have a problem here. Can we compromise? Isn't it something like that that happened?
Your Honor, as explained by Donald Singh, when GGMC was going about its due diligence studies in relation to Diamond application, which apparently Diamond did not do, GGMC was required to go on the ground and inspect the premises. Then they discovered that Baraca had a license for premises next door, but had not been occupying those premises, but had been occupying the premises which Diamond had applied for. So that was when the discovery was made, when GGMC went on the ground and saw this activity, the quarrying activity going on.
But doesn't appear as if
GGMC,
Mr. Ramkran, does GGMC not check this every quarter? According to what I read from early 2000, they go to these places to check. There are reports, all of that. So wasn't that known that Baraca was working there?
It was very much known that Baraca was working there. The report that we tendered shows that, but it doesn't appear as if the report checks what area is covered by the license and what area is and whether the person is working on the area covered by the license. It appears as if it is assumed that the person is operating, the person or corporate body is operating in accordance with its license, and then it moves on from there and checks other stuff which is reported, which is set out in the report.
Yeah, well, a supervisory institution should not assume anything. They should know.
I agree with that. I have no answer to that. To GGMC's not having this issue having fallen through the cracks. That's clearly what has happened. Your Honor, the issue of the subdivision, which was found by the trial judge, we're not appealing. The question was asked of us, what are we going to re-argue? And if GGMC made the submissions on behalf of Diamond in its submission in answer to us sought, or the submissions in relation to the cross appeal, well, what if GGMC made no decision on the subdivision? What are you arguing? Your Honor, Diamond made no decision on the subdivision, but the Chief Justice made a decision on the subdivision. Not only did he make a decision on the subdivision, Your Honor, the Chief Justice launched a blistering attack on the integrity of the GGMC without any evidence whatsoever.
But apart from that, you are clearly saying, okay, we suggested a subdivision. It was not accepted in the end. Maybe it was accepted in the beginning, but certainly not thereafter. So that whole subdivision is off. Is not an option anymore.
No, Your Honor,
is that correct?
Yes, Your Honor, but I'm respectfully asking this court to set aside that order as to subdivision, because this is what the Chief Justice said, Your Honor, at page 346, this second half of the second paragraph. He said the decision made by GGMC in the matter is certainly not in consonance with administrative fairness and propriety, and does much to foster public diffidence in GGMC's ability to make administrative decisions uninfluenced by improper considerations. Your Honor, the mining industry is the largest single industry in Guyana today, save and except the developing petroleum industry. GGMC is the statutory body that controls the mining industry, issues mining licenses of various types, claims licenses, mining license, medium scale, large scale, and so on. GGMC also is involved in the petroleum industry. To make these remarks about such a major institution, Your Honor, brings it into disrepute for no reason and on the basis of no evidence whatsoever. And that is why we are respectfully asking this court to set aside that order and to expunge these remarks from the decision of the Chief Justice. And what we are respectfully submitting, Your Honor, is that the order made by the certiorari order made by the Chief Justice is the base of a tottering superstructure, if Your Honor will permit the expression. And that tottering superstructure consists of two poles: the pole of the order of prohibition and the pole of the order of mandamus. The prohibition order would not have existed, and the mandamus order would not have existed without the certiorari order. They are all related and intertwined. Because the Chief Justice ordered that this land must not be subdivided, he went on and prohibited GGMC from giving the land to anyone else, to any other person or body, apart from Diamond Quarry. And then he went on and ordered the mandamus, ordered GGMC by mandamus to issue the license to Diamond Quarry. And what the Court of Appeal did was to maintain the prohibition, maintain the certiorari, maintain the prohibition, then tells GGMC, you make an order, we give you discretion to make an order of mandamus, but the effect of our order, the Court of Appeal didn't say so. I'm submitting that the effect of our order is that the only thing you can do is grant the license to Diamond Quarry. Your Honor, this is unsustainable, this is unacceptable, and I respectfully submit it ought to be set aside.
Let me ask you this. If GGMC leaving apart a mandamus order, if GGMC took it upon itself to grant the license to Diamond for the entirety of the area that Diamond has applied for, would it be liable to Baraca in any respect?
Your Honor, I have mentioned this in my submissions. I haven't addressed it at length, but I have mentioned it as a possibility. Your Honor, if Baraca is lawfully entitled to occupy any portion of the land by virtue of the 2006 advertisement in the Gazette, which gives it the power to occupy, and if it is entitled to occupy any portion of the land by virtue of the infrastructure that it has on the land, and by virtue of Regulation 70 of the mining regulations, Baraca clearly has a case against Diamond. Your Honor, the other point made by Baraca, use the words nec vi, nec clam, nec precario. Baraca has been occupying this area for 40 or 50 years.
Yeah, Mr. Ramkran, that can't fly because they can't be occupying it at the same time claiming a license. But look at it another way now. Much as you abhor the fettering of the Commission's discretion by the court, if in fact the court issues that mandamus, then Baraca can't, you can't be liable to Baraca because you obey in the court.
If the court issues an order, sir, we can't be liable. GGMC can't be liable if the court makes an order. But I respectfully submit in the circumstances, the court ought to allow GGMC to utilize the discretion that it is given by law. Your Honor, if you read the case, I think it's Comm'r, the case of Comm'r, where a cease work order was issued, but the court directed that a cease work order be issued. And the Court of Appeal set aside that order and said, look, the cease work order under Regulation 98 has to have considerations giving rise to it. And those considerations can only be exercised by GGMC in its discretion. So they removed the mandamus and referred the matter back to the GGMC for consideration as to whether the cease work order should be issued. This is the same thing I'm saying here with different circumstances. GGMC can no longer ignore, if it didn't have the facts at the time, as it appeared not to have had the opportunity to deal with those facts or to unearth those facts, referred to by Ashik Rahman in his affidavit. If GGMC didn't have the facts at that time, it certainly has those facts now from this case as it has proceeded and it has disclosed all of these materials. GGMC certainly has those facts now, and GGMC needs the opportunity to consider all of the circumstances, maybe even go back to Diamond Quarry and say, look, this is something that we ought to reconsider again, whether to subdivide. But in any event, it needs to have the opportunity to consider all the circumstances that have emerged since the filing of the case.
But you see, Mr. Ramkran, looking at the position from Diamond's standpoint, if the Chief Justice's orders are not are set aside and the matter is put back in the hands of the Commission, don't you think that Diamond would feel justifiably hard done by, especially if they harbor a thought that the GGMC is not, I don't want to go there, but if they harbor the view that they did everything possible to justify them getting the license, and after they've done everything, they haven't done anything wrong, there's a do-over. You know, it's like, you know, somebody hold you down. It's not a no ball. You're well out. But the umpire says, no, that's a no ball. You have to play again.
Your Honor, that might well be so. What Your Honor says might well be so. But the facts as presented to us compel us in a certain direction. It compels us in a direction. There is, in my respectful view, no basis on which this honorable court, and Your Honor, please permit me, please excuse me for being so frank. There's no basis on which this honorable court can auto sustain the order of certiorari made by the Chief Justice. And if this court agrees with me and finds no basis to sustain that order, then the other two orders have to go. When these two orders have to go, what do we remain with? We remain with the discretion to be exercised by the GGMC. That's what we have before us.
Just to get back to the subdivision, the subdivision was crafted in order to accept from what Diamond had applied for, the lands in occupation by Baraca. Is that it? Or
yes.
Was the
the subdivision was essentially to give Baraca the portion that it was occupying. I think the subdivision was in relation to the infrastructure that it had on the land, just to give Baraca that portion, that infrastructure portion that it was occupying, and give the rest to Diamond. That's still a feasible proposition, but whether Diamond will accept it or not, I don't know. Your Honor, I have concluded my time, and I would like to, unless there's anything else that Your Honor would like to hear me on, I have barely touched my notes when I look at them, so there's much more to say. Unless there's anything more, Your Honor, I would ask Your Honor to kindly give my junior an opportunity to deal with some of the legal issues which have arisen and which I have made submissions on.
Yes.
Thank you very much, Your Honors.
Mr. Ramkran Jr., how long do you think you would be?
Just a few minutes, Your Honor. Not very long.
Yes.
May it please, Your Honors, there is a single issue which arises for consideration in this case, and that is the issue of legitimate expectation. That single issue is founded on a single complaint that GGMC promised Diamond Quarries a quarry license, and it seems to now be resiling from that promise. Despite the fact that this seems to found the entire case, there are many red herrings which have taken center stage, as Your Honors will see. The issue of subdivision is one. Subdivision was just the manner in which the resiling from the promise, if there was a promise, seemed to be taking place. The GGMC, if there was a promise to issue the license, when GGMC said proposed subdivision, that was the resiling from the promise. As a consequence, the principles of legitimate expectation have not been applied to the facts or analyzed either by Chief Justice Chang or by the Court of Appeal before determining that Diamond Quarries was entitled to a license. No other ground of judicial review in my submission, Your Honors, would lead to the compelling of the issuance of a license. The GGMC clearly has the discretion to exercise when it considers applications for licenses, and it is clear in the law that when a statutory decision maker has a power to exercise that decision maker, no other must exercise it. Of course, if the decision is tainted by illegality or irrationality or procedural impropriety, it is liable to be set aside. But the body must have a duty imposed on it as opposed to a discretion before it can be compelled to do something. And in this case, GGMC can only have a duty to grant a license to Diamond if Diamond has a legitimate expectation to the issuance of a license. Although the Court of Appeal has modified the mandatory order of Chief Justice Chang by ordering GGMC to determine the issuance of the license to Diamond according to law, the prohibition ordered by the Chief Justice is still in place, and this prevents GGMC from issuing a license over the land to anyone else but Diamond. So in effect, GGMC is still compelled to issue the license to Diamond, and in any event, Diamond has appealed the modification of the mandatory order to this court, So the issue of its legitimate expectation to the license remains at center stage. The Chief Justice and then the Court of Appeal, and then the Court of Appeal on rehearing the appeal should have engaged with the principles of legitimate expectation in order to properly analyze the issue of Diamond's entitlement to a license. They fell in error when they did not do so, and their failure to properly consider and apply those principles led them to an incorrect conclusion. The first issue which should have been considered in my submissions, Your Honor, is whether Diamond's expectation was legitimate. It is well established in the authorities, including cases from this court, that there must be a clear and unambiguous representation devoid of qualification for the expectation to be legitimate. That representation must be induced by the conduct of the decision maker, and it must be made by a person with actual or ostensible authority. The second issue, Your Honors, is the issue of fairness looked at against the backdrop of abuse of power. Even if all of the factors exist to show that the expectation is legitimate, it must be so unfair for the body to take a new and different course that it will amount to an abuse of power. This court must now consider and determine whether there is an expectation which is legitimate, and if so, whether it is unfair to Diamond to amount to an abuse of power for GGMC to result from that expectation. Is there a clear and unambiguous representation devoid of qualification? Whether or not Baraca is here in this court, the fact of its occupation of the land and the evidence put forward by it in the Court of Appeal must be considered by the court to determine whether the occupation of the land is a qualification which applies to Diamond's interest in the license. It cannot be a clear and unambiguous representation to issue a license if there is the possibility of someone else's interests which have to be considered and resolved by the person who has the statutory authority to make the decision. In any event, the publication of the notice in the Gazette at page 253 of the record says, save and accept all lands lawfully held or occupied. This is something which has to be considered.
Can lands be lawfully occupied if the occupier does not have a license?
Well, Mr. Ramkrant dealt with that issue of the lawfulness of the occupation. But even if you look past the notice on that save and accept clause, the lands are, in fact, the lands are occupied, whether lawfully or not. They are occupied and there's infrastructure on them, according to Baraca. So this is an issue which affects the representation. It is an issue which qualifies it. It is a qualification. So in order to accept the GGMC promise to lease to Diamond, the court has to accept the evidence of Diamond and reject the evidence of GGMC. But how does the court do this? Diamond has the burden of proof, and GGMC has not accepted its version of the facts. Usually a person does not prove this case if there's no cross-examination and the situation arises. So it would be a stretch to conclude that there's a clear and unambiguous representation to Diamond from GGMC. And then if we move on to whether the representation was induced by GGMC, the matter was not resolved. It had not concluded when Diamond approached the court. All of the facts leading up to the commencement of the proceedings must be considered, and the representation cannot be taken from part of the factual matrix while leaving another part of the facts to one side. The facts are that GGMC was trying to resolve the situation of Baraca's occupation of the land along with Diamond's application, and those are all part of the representation which was made to Diamond. Another issue to consider is whether the promise to Diamond, whoever made the promise to Diamond that they would get a license, had the actual or ostensible authority to make that promise. Diamond does not say in its affidavit who promised it the license. It doesn't name people. And GGMC says that no promise was made. Can it be established to the satisfaction of the court that whoever promised Diamond, if in fact that promise was made, had the actual or ostensible authority to do so? How can we arrive at such a conclusion? It is not there on the facts. But even if all of these things were established, Your Honors, and Diamond does have a legitimate expectation to a license, would it be so unfair as to amount to an abuse of power for GGMC to try to resolve the matter by taking all interests into account? The court must look at all of the evidence before it and all of the explanations before it arrives at the answer to this question. The fact that Baraca is not before the court should not, in my submission, prejudice its rights. The court has to consider whether the options which were put forward to Diamond, or since the matter was not finished before court proceedings began, whether there are options which GGMC can put forward now to Diamond to employ fairness both to Diamond and to Baraca. And I note Your Honor's question, Justice, the President's question, as to whether Diamond would not now feel that it has been put into a situation where GGMC is against it and GGMC favors Baraca. To avoid such a situation, it is possible for the court to set a report date before issuing decision. It is unusual, but it is possible, so that the court is aware of what is happening. This would be an unusual step, and I suppose a last resort if a decision cannot be reached. But another question to consider is whether there is an overriding public interest, or whether there are overriding interests to be considered in the face of Diamond's legitimate expectation, if one can be found. Baraca is already on the location and is already in a position, according to its evidence, to quarry stone. Now, Guyana is comprised of 83,000 square miles. Is there no other place that Diamond can be given a license for which could satisfy it? Shouldn't these matters be the subject of consideration and discussion between the parties before a resolution is arrived? This is not a case, Your Honors, where the court should determine what the issues are. The decision maker should be able to determine what the interests are and to balance those interests with fairness to arrive at the right decision. Your Honors, this case seems to have Solomonic overtones down to the division of the baby. And the court has to balance all of the interests carefully to arrive at a solution. It should be mindful that dismissing the appeal will mean that the court and not the GGMC has exercised its discretion to give Diamond a license when none of the courts who have considered this matter have full knowledge or expertise in the area of quarrying. Unless I can be of further assistance to you.
Could I ask you just one small question, please, Mr. Ramkaran?
Yes, sir.
Assuming that Baraca was not in the picture at all, that there was no conflict with Baraca, would you agree that, bearing in mind the interactions between Diamond and the Commission, you know, Diamond searched, there was nobody in the area that it was applying for, made its application, submitted all the documents. It said it had a promise from somebody at the Commission. Then, of course, there was a notice published in the Gazette of the intention to grant the license. If Baraca was not in the picture, would you agree that it would be legitimate for Diamond to argue that it had a legitimate expectation that the license would be granted?
I think that the answer to that question, Your Honor, even if Baraca was not there, the end result is subject to what is on the ground at the moment. And the expectation to a license has to be taken into consideration what actually exists. So suppose there was no quarryable stone in the area. Diamond has done research from the records. There's no evidence that Diamond actually went onto the area to see what was there. And these are huge, huge areas of land, over 1,000 acres in one case and over 800 acres in another case. Even if you were to go there, you wouldn't probably see everything that's there. I would say, Your Honor, that the question cannot be answered without considering all of the facts, even if Baraca was not there. Because Diamond would have gotten the license if Baraca didn't come into the picture. from the way things were going, there was the notice in the Gazette. It seems that the Diamond would have gotten the license. I must say, Your Honor, that I know nothing more about this case other than what is in the record, like Your Honors.
Yeah.
So I have no outside facts.
So they would have gotten the license, and they would have had a legitimate expectation that they would have got the license. But for the fact that there is Baraca in the picture, that's all I'm asking. And that's...
No, sir, because putting a legitimate expectation here takes away the discretion of the decision maker. You are stopping the decision-making process before it comes to an end by saying there's a legitimate expectation, by saying that there is a promise somewhere. I promise you that I will give you the license. Well, the giving of the license is the promise. So there's no need to stop halfway between the beginning and the end of the decision-making process to put a promise in. The promise is the license. If you're going to get a license, you're going to get a license. But you don't need to stop that promise halfway to say, oh, you promised me a license and therefore I should get it before the decision has been made. The decision maker should be allowed to carry the decision-making process to the end without the intervention of the court, except in the rarest of circumstances and the clearest of circumstances. Your Honors will know.
Mr. Ramkaran, of course, you also know that one can, by its own conduct, fetter its own discretion.
Yes, certainly.
Yes. So once you have certain conduct, then you, on your way, you more or less narrow the possibilities that you have yourself. Although you have, of course, this discretion, you narrow it down by your own conduct sometimes. But anyway, we understand your point. So now you were saying that you don't know more about the case than what we can find in the record. But you know, I suppose this is typically for lawyers and judges. But as a normal person, you would ask the question: so what is happening since 2015? Is this cease work order still in place? Is no work being done? Can you answer that by, or it's not in the record, of course, and you cannot give evidence from the bar. We all know those principles, but you know, one would like to know what is happening there. Everything is stopped.
I am not in a position to say.
You're not in a position.
From the record, that would be the situation.
That would be the case. While everybody was saying that there is such a necessity of getting stones, etc., and that's why Diamond wanted to have the license, and that's why Baraca wanted to extend their territory, etc. But so the common sense result is that nothing is happening in this area since 2015. That's now 7 years, correct?
Your Honor, I'm aware that Baraca had applied for a stay of execution in the Court of Appeal. I see the application on the record. I don't know if they got that stay of execution in the Court of Appeal of the Chief Justice's order. Perhaps Mr. Ramkaran or counsel for the respondent can assist in this regard. But if they did, they would have been quarrying in the meanwhile until the decision of the Court of Appeal.
But another point is that what you're really suggesting is, well, we could come together and find a practical solution for our problem. Is that what you were saying? We were talking about, well, maybe if they can't get this part, there are other parts that they could use, etc. So I was hearing something like maybe we can get to a settlement.
It seems to me, sir, that is what they were doing before the court proceedings started. Now, I would only suggest a settlement, of course, if Your Honors were minded to dismiss the appeal. If Your Honors were to allow the appeal, then that is fine. The parties can settle it on their own. And they are always free to go back to court if things are not done in accordance with the law. Having regard to the fact that this case has gone through the system and there are many lawyers looking at it, I am of the view that the next time around, there will be a lot of eyes giving close scrutiny to what is happening. And GGMC is aware, and all of the parties are aware that we could be going back to court. So I think that this time around, the matter would be dealt with more carefully.
Yes, because as we discussed with senior administration is not the strongest point, it seems, of GGMC. And while it should be a strong point because you have to supervise all these activities properly. And in this case, that surely didn't happen. And not talking about other cases because I don't know, but in this case, things went wrong. I think we can say that, administratively at least.
If you look at the affidavit of Robeson, Ben, Your Honor, you will see that he refers to the way that they mark boundaries. And perhaps it's a technological issue which is on its way out, the marking of boundaries so that there is no mistake. There's a certain way that it used to be done and mistakes used to be made. Remember, Your Honor, these are huge, huge areas of land. Yes. Over 800 acres and over 1,100 acres.
Yes, but the administration could have been better. Won't you agree?
It could have been better. But you know, Your Honor, there's an issue of resources in Guyana. Guyana is a small, underdeveloped country.
Yeah, but this is important. And I don't think it has to do much with enough resources. This is, this has to be done accurately. If not, then you will lose confidence anyhow. But before we end with your side, so is it that you are at least suggesting that, and then we will hear from the other side, that you are suggesting that maybe we could settle this as grown-up people and let's say ask the court to hold its fire for a while and see if we can get there? Is that what you're suggesting?
Subject to senior counsel's concurrence, Your Honor. I went out on a limb without discussing it with him, so I must remember that I'm being led by senior counsel.
Yeah.
Such propositions are.
Sometimes you could also forget that. I think senior would be as pleased as you were with some practical solution, but let's see, it takes two to tango, so the other side is also, certainly will also have an opinion. So thank you.
Thank you, sir.
Yes, thank you, Mr. Ramkran Jr. And I take it that's the end of your side's submissions.
Yes, Your Honor.
Okay, Mr. Lakou or Mr. Jonas?
Good morning again, Your Honors. Mr. Lakou has asked me to deal with the geography of this issue. So with your permission, please, I would like to go through that aspect of it.
Mr. Jonas, I don't know if you are tech savvy enough to share a map, because there have been several maps in the file. I think that makes things a little clearer. There is a map which shows us this subdivision, which is at page 126. Is it that you can put that on screen, or should we do that?
Your Honor, earlier, the court, Mr. Justice Sanders, I think, was the main person involved, where it was drawing analogies to cricket. And internally, I thought poor Justice Witt may be at a disadvantage in this conversation. There's a certain justice here, sir, because you've just asked me about technology and immediately put me at a disadvantage. I'm afraid that I cannot help in that regard at all, but I would happily follow if those plans were put up. But I can refer, Your Honor, to the page numbers of the record where those plans exist.
Yes, tell us the page numbers.
Yes, please, sir. Allow me to start at the beginning, if I may, sir. I will get there in less than 5 minutes.
Good.
Your Honors, I heard with some alarm my friend on the other side say that as this case progressed through the 2 tiers of appeal after Chief Justice's decision, information came in which should inform and justify decisions by the GGMC changing its mind or taking alternative courses. Your Honor, that worries me, because the decision of the GGMC as challenged is when the decision was taken, and the issues which arose for determination by Justice Chang must be assessed as they arose before Mr. Justice Chang. And for that reason, I would like to go to that beginning. We're in appellate court, and we must review what appeared before Mr. Justice Chang to see what he did and whether it is vindicated or not. My friend raised the issue of the right of Diamond to the grant of the order sought, certiorari mandamus prohibition, seeking essentially to secure to itself this nearly 1,000 acres of land that it had been promised, and suggest that no such promise was made. So the starting point, Your Honor, is the affidavit in support of motion by Comm'r, which is at page 245 of your record, and in respect of which everything is admitted except paragraph 5. So if I can start at paragraph 4 of Mr. Comm'r's affidavit. This is page 245, please.
Yeah.
Thank you very much. Paragraph 4, I made an application in accordance with section 8 and 9, so I applied. Paragraph 6, I'm sorry, that is admitted by Singh in his affidavit in answer. Paragraph 6, I paid the necessary fees, complied with all statutory requirements in my application. Attaches Exhibit B, that is admitted by Singh of the GGMC. Paragraph 7, following payment of fees, GGMC wrote me asking for the following additional documents. Paragraph 8, I complied. All of these things are admitted. Paragraph 9, in their letter, GGMC says, and here's a promise, please. GGMC has favorably considered your application and an intent to grant quarry license will be published. I believe that's unequivocal. The statutory authority has received the application, asked for further documents, received the required payment, and have said we favorably consider this thing. We will be publishing it. And why do you publish? Forgive me, Your Honor, paragraph 8 is admitted. Paragraph 9 is admitted. Paragraph 10, they published in the Gazette, which is our official publication nationally. Paragraph 11, which identifies the purpose of this publication to the public, to tell the whole world. Anyone who has an interest, you have a period of time, 21 days, to put in your objection. And the reason for that is clear. 21 days passed, Diamond must get their license. So when at paragraph 12, which is admitted, Comm'r says, no one lodged with GGMC a petition objecting. We have gone a long way toward the grant of this license to Diamond in accordance with the application, payment of fees, further documents, and the unequivocal statement by GGMC, we're giving you this thing. The one equivocation, please, Your Honors, is by GGMC in respect of paragraph 5 of the affidavit in support, in which Mr. Comm'r says, and this is at page 246, before making the application, I did the necessary research to ensure the land applied for was not legally held by anyone, nor applied for by anyone. My research revealed that from the records available at GGMC, no one had the right or interest in the area for which my application was based. The response from GGMC in their affidavit in answer is unfortunately equivocal, but it does not deny paragraph 5. At paragraph 6 of his affidavit in answer, this is at page 262 of your record, please. At paragraph 6, Donald Singh says, I don't admit it, I don't admit paragraph 5. And then this is what Donald Singh says. A portion of the area had been occupied for several decades by Baraca, which conducted quarrying activities thereon. and he attaches a report, the last report of the respondent, to assess the quarrying work done, GGMC1. And for our purposes, please, Your Honor, what is relevant at GGMC1 is at page 288 of your record. Can I go on, Your Honors?
Sure.
Thank you very much. That is page 21 of the report that Mr. Singh refers to from GGMC, and it speaks to the monkey jump occupation at Baraca. 2 quarries, one on the right bank, the other at Big Hope, which is some distance away, not relevant for our purposes, although there's an attempt to conflate the two at the level of the Court of Appeal. Rocks blasted at Monkey Jump, usually transported. Doesn't say where, somewhere at Monkey Jump. And then the third paragraph on that page, please, has this observation by the report by the GGMC official. And Your Honor will note the report is dated at page 267, 31st March 2015. During the inspection at Baraca, Monkey Jump, it was observed a small activity was going on. There were 9 employees present. We don't know exactly where this is, but somewhere at Monkey Jump. And then the final paragraph says, a cease order had been issued on this operation since previous October 2014. GGMC had issued a cease order in October 2014 in respect of this occupation that they're talking about here. So when Donald Singh says in his affidavit in answer, which is the material before the Chief Justice, he's not admitting paragraph 5, but a portion had been occupied. And he refers to this exhibit. This exhibit is saying we find the portion occupied, shouldn't be occupied, cease order issued since October 2014. And therefore, the issues which arise before the learned Chief Justice for determination, being faced with Diamond's application saying, I've done everything I'm supposed to do, I was promised this thing, these people are backing out, is Donald Singh saying, we find somebody in occupation. He doesn't say in his affidavit it's wrongful occupation and a cease order was issued. But the report that he attaches says it's wrongful occupation and a cease order was issued. So the question for determination by the learned Chief Justice is, was the nature, legality, effect, and extent of this occupation? And if the occupation is lawful, what rights would it vest? But of course, if the occupation is unlawful, we know that under the Act is an offense and certainly can't justify GGMC saying we change our minds. And that is all the Chief Justice found. So when the learned Chief Justice said, Your Honor, I'm sorry, the other point that Mr. Singh sought to make in his affidavit was that Baraca had applied for an area. And Your Honor have heard the appellants who continue, unfortunately, to blur the very clear fact, which will be apparent upon review of the plans, that the area that Baraca did apply for in 2006 is to the north. It is not the area that involves Diamond. It is not the area that Diamond applied for. But we will see that very clearly. So the two questions are, this occupation by Baraca, does it justify GGMC changing their mind? And where was, as an aspect of that, where was Baraca lawfully entitled to be and where had it applied for since 2006, since Mr. Singh of GGMC seems to be basing some kind of importance on this 2006 application? The two are interlinked because if there can be a finding that Baraca was lawfully occupying or had lawfully applied for some portion that Diamond Fire is now going for, there may be a conflict of legitimate interests. Learned Chief Justice, having looked at the affidavits, said, and this is at page 344 of his decision, it's clear in the affidavits, I'm reading from halfway down the page, please, that Baraca Quarries did not make any application for a quarry license. So that's his first finding, they didn't make an application. It's also clear if it was carrying on operations, so if it was in occupation, on any part of the land subject to Diamond's application, it was doing so illegally without a license. The Learned Chief Justice could have made no other finding on the material before him, because there is a clear application by Diamond that identifies their portion, and the only dispute raised by GGMC as to why they're changing their mind is one occupation which they themselves have put a cease order for because they said it was illegal. And what the appellants are relying on, interestingly enough, is an order that is at page, a report, I'm sorry, from GGMC, that is at page 256 of your Honor's record. This is the single straw that is grasped by GGMC. Your Honor will see that this report is dated 10th February 2015. And it's a couple days, 2 days, after the meeting that the GGMC called between Diamond and Baraca. So it is the report by GGMC as to what transpires at this meeting. Your Honor will see it's signed by the same Donald Singh, who is the deponent to the affidavit in answer by GGMC before the Chief Justice. In that report, background, first paragraph. GGMC has accepted 2 quarry license applications from Baraca Quarries and Diamond Quarry dated 26 June 06 and 28th March 2014, who have both applied for the same area. That is an inaccuracy. I wouldn't go as far as to say it's a falsehood, but I have my suspicions. But it's certainly an inaccuracy, and we will demonstrate that. They didn't apply for the same area. And the same Donald Singh, who signed this 2 days after the meeting, in his affidavit concedes it's not the same property. So the only strand that GGMC is holding on to before your honors is this statement here in Exhibit C2, that they apply for the same property. Your honors, nowhere else in this record of appeal before you is there any suggestion that the application dated 26 June 2006 is for this property. In fact, every other document that we will refer to demonstrates clearly, unambiguously, the application in 26 June 2006 is for the area north, the 1,200 acres. And Your Honor, I deliberately say 1,200 acres because we will identify it. One as 1,200 acres where they applied for in 2006, and the second 1,628 acres where they say this is what we really want now. So in 2006, they applied for 1,200 acres to the north. And insofar as we seek before the Chief Justice an order for certiorari to quash a decision by GGMC to subdivide, Your Honors will note that the meeting, according to Mr. Donald Singh, had an outcome at the bottom of page 256. In his report of the effect of the meeting, he says, and if I can refer you please to the next page, 257, the area will be divided into a northern portion which will be granted to Baraca, provided all conditions are satisfied, and Diamond will be granted the southern portion, provided all conditions are satisfied. Now, Your Honor, this is under the heading outcome. So this is the outcome of this meeting. And there's no prevarication here. Donald Singh is telling us what's going to happen. On behalf of GGMC, he is informing there's going to be a subdivision. This is the statutory authority. This is not your equal bargaining partner. This is the statutory authority telling you what the outcome is. Now, insofar as GGMC continues to pretend that, as this C2 says, in 2006, Baraca applied for the same portion, may I refer Your Honors, please, back to paragraph 9 of the same Donald Singh's affidavit before the learned Chief Justice. This is at page 263. Can I go on, Your Honors?
Yes.
In the year 2006, Baraca had applied for an area north of the area it occupied and was granted a quarry license. Baraca claimed its intention was to apply for the area it was actually occupying, and there was a mistake. So the same thing who in C2 pretends that is the same piece of land both applied for is now before the learned Chief Justice acknowledging no. Baraca in 2006 applied for Peace North.
Which of these two documents was signed first in time? What are the relative dates of these documents, this affidavit and the report?
The report is 2 days after their meeting on the 10th of February 2015. And the affidavit in answer before the learned Chief Justice is 4th of June 2015, after Diamond, seeing that report, went to court. And the affidavit in answer, therefore, is an answer to that several months later. Your Honor, please allow me now to go to the geography. The first point of departure, please, Your Honors, should be at 79 of Your Honor's record.
Sorry, what's the page number?
79, please, sir.
79.
Yes, please. Now, 79 is actually the culmination of 4 pages, an exhibit which is 4 pages. But I'm referring to 79 because it shows you the picture. It shows you the plan of the area which is in question. In the 1970s, 1974, Baraca was given 21 acres of land on the right bank of the Essequibo River. The plan of that 21 acres is shown at page 79. Now, my friend Mr. Ramkaran, when questioned by Your Honors, has said that this piece of land is not involved in what we're speaking about now. It's somewhere else. So, Your Honors, insofar as some application and some licenses granted for 21 acres of land back in 1974, I will let that lie because it does not affect 1,200 acres or the 1,628 acres which we are now dealing with. I will, however, respectfully make the point, Your Honors, that 1,600 acres of land is 2.5 square miles, 2.5 miles wide, 2.5 miles long, or 6.5 square kilometers. Now, Your Honor, my friend Ramkaran Jr. adverted to size, and he's right. Allow me a bit of patriotism when I say if you sail down a river and you see dense, impenetrable foliage, you don't have a clue what geographic point you are, what point north of the equator, what line of longitude or latitude, and you certainly do not know what's 2.5 miles inside. So GTMC relies on its records. And when you're applying for a piece of land, you take your surveyor and you do your survey and you do the plan and you submit it to GGMC. And their record keeping consists of the accumulation of all of these applications and grants which are made. And according to their records, they do their surveys. Your Honor, Mr. Singh says that Baraca has been in occupation of 2.5 square miles of land. 1974 plan, which is here at page 79, speaks to 21 acres, much more realistic figure. The next following page shows the two areas we are speaking of, please, Your Honor. Page 801.
Maybe we could have on the screen.
Thank you very much, sir. Okay, sir. Your Honors, I don't know if it could be placed a bit higher. There are two areas of land shown. Thank you very much. That was a bit too high. Yes, we could leave it there. Thank you. Your Honors will note that, Your Honor, north is upward. Your Honors will note that the semi-peninsula where Monkey Jump is stated to the north, and then to the south, Baraca Quarry proposed extension. That area to the north is 1,200 acres of land. The area to the
that's this area where the cursor is jiggling around?
Yes, please, sir. It's circled in green. Fortunately, the court's copy is better than mine, which is black and white.
Mm-hmm.
Your Honors will see it is in green. 1,200 acres of land. I'm deliberately repeating 1,200 acres, yes. The one to the south is 1,628 acres of land. Don Singh says, in 2006, Baraca applied for land to the north of where it occupied. It was in occupation. What Baraca applied for is that 1,200 acres circled in green.
Yes. Monkey Jump.
Yes, yes, please, sir. And if I can refer Your Honors, please, to exhibit, Your Honor, I will take you please to page 100 of the record. I'm sorry, 102 of the record. Your Honor, I may be making your registrar's life more difficult if she follows us. I'll ask your registrar, if you don't mind, if she can stay on that page where the plan is. And when I take the registrar to another plan, I will alert her the best I can, and I apologize for my inefficiency. So I hope the registrar forgives me.
You want it to be on page 79?
Yes, please, sir. But Your Honors, can I take your attention, please, to page 102 of your record?
Okay, I'm going to ask, I'm actually doing this. I'm going to ask the registrar to take over from me. That's okay.
I envy you your facility in that regard, sir.
So I'm going to close my screen and I will ask the registrar or one of the registry officials to put us on page 79.
Mr. Jonas, you wanted us to go to 102 now?
Yes, please. Yes, please, Your Honor.
All right. And
can I go on, Justice Saunders, Mr. President?
Yes, go ahead.
That's not a plan. Yes, thank you.
I'm sorry, Justice Lee.
I said that is not a plan.
No,
Thank
please.
You. Yes, thanks a lot.
Your Honors, on the 20th of June, 2006, and Your Honors will resonate 2006, Baraca, the same Ashik Rahman who signed the affidavit in the Court of Appeal on behalf of Baraca, asked and applied for quarry licenses for two areas. The first is not relevant, Big Hope, far away. The second, Monkey Jump, 1,200 acres. So that's his application. If I can take your honors, please, to page 108, which is all part of his application in June 2006. Your honors will see the application by Baraca for the 1,200 acres, 27 NE in mining district number 3, Mazaruni. And then the next following page, 109, carries the coordinates. 27 northeast, 27 southeast, number 3 Mazaruni. And your honors will see at the bottom of that description, after they take you to the longitudinal and latitudinal points, so that the area can be identified. It says, thus containing an area of approximately 1,200 acres. And then the next following page shows the plan that the application refers to, the 1,200 acres on the right bank of the Essequibo River. That is the correct page, yes, please. So your honors will see that in 2006, if we go back to page 79, this diagram that you see there of Monkey Jump on the peninsula, comprising 1,200 acres, yes, please. Yes, please. That's it, please. Thank you very much, sir. Your honors will see that 1,200 acres circled in green is what Baraca applied for in 2006.
So you're saying that there was no mistake in coordinates because they painted it out, as it were. This is the part they wanted.
Yes, please, sir. For clarity, we show it on a plan. The application comes with a plan and attaches a plan. And Your Honor, I will go to the coordinates, but visually, the 1,200 acres is identified so consistently that there's no mistake, there's no error.
Correct.
Very much, sir.
And just to be clear, you're saying that this is not the area of Monkey Jump that Diamond is concerned with?
No, please, sir. Diamond is concerned with another area of Monkey Jump, which falls within the 1,628 acres south of that.
I see.
So the larger defined portion, Diamond's area is within that larger defined portion.
Okay.
Do you have that on a plan that you can show us as well? That would be as well defined as what we're seeing at, I think it's page 81 we're on.
Your Honor, we are on page 81. There is not on your record a plan of the Diamond application for 800 odd acres because, well, I can't say because. What I can respectfully point out is that that issue did not arise before the learned Chief Justice. It is agreed that Diamond applied for the land and Baraca then said, we are in occupation of this land. It is to the south of this area that we had applied for in 2006. So the question of the overlap of that 1,628 acres was not an issue between the parties, and there is not on your record a copy of the Diamond plan. It falls within that 1,628 acres.
Thank you.
Your Honors, if I can then take you, please, to page 83 of your record. Page 83 is Exhibit G, referenced by Baraca. This is the affidavit of Ashok Rahman on behalf of Baraca filed in the Court of Appeal. And this Exhibit G references a GGMC survey of the occupation which it found by Baraca. Oh, Your Honors, what is on your screen is small, but you will see in the upper left-hand corner, separately in the upper left-hand corner, the 1,628 acres. It's got in the inset, yes, that's 1,628 acres. You will see that that is the 1,628 which falls beneath the 1,200 acres. 2.5 square miles, 6.6 square kilometers. And the GGMC survey said, this is the portion that we have found Baraca to be in occupation of. Unlawful occupation because they never applied for it, never got a license for it. But on the evidence of Baraca in the Court of Appeal for the first time, this is where they're in occupation. Maybe 0.5% of the 1,600 acres. In the northeast corner, which has one small road, a few buildings, and the inset shows what portion that larger occupation area refers to. This is the basis, undisputed and as presented by Baraca, relying on the occupational plan as done by GGMC of the extent of their unlawful occupation of the land to the south of the 1,200 acres in respect of which they had made an application in 2006. That fly spec. Maybe 2 acres. So the evidence, Your Honor, is consistent throughout. Baraca was in illegal occupation, as the learned Chief Justice found. Baraca in the Court of Appeal said, nec clam, nec provario. Illegal occupation of an undefined portion. But the plan before Your Honors there is the survey plan which tells you where the occupation was found, the fly spec. And that, again, is an area they had no license for because the license that they had applied for in 2006 was to the north, the 1,200 acres, which again consistently is identified both on their application and on the various plans as 1,200 acres at the peninsula of Monkey Jump. And therefore, I respectfully do not understand the continued argument either that Baraca had some license that overlapped Diamond, or that its occupation, which even Singh, the author of Exhibit C2, later on concedes, well, what they were applying for a license for and didn't get a license, were applying for a license for in 2006, was to the north, that 1,200 acres. The fly speck of occupation here, which has nothing to do with 1,628 acres. Even if it did, it was illegal. So the question then arises, Your Honors, if GGMC appeared before the learned Chief Justice Chang to say, yes, we favorably approved the application by Diamond, and yes, we demanded more documents, which they provided, they paid the fee, we told them we're going to do it, we advertised, nobody opposed, but we've changed our minds because Baraca tells us that they're in occupation and we didn't know, even though that occupation is unlawful and a crime. I respectfully submit that the learned Chief Justice really did not have to reach far to make the findings that he did, that the occupation, if it did exist, and to the extent that it did exist, was illegal, and that The 2006 application was in respect of another area, which is to the north. And the only question which remained was, were there any grounds put before the Chief Justice in GGMC's defense which would justify a court saying, you know, there are other criteria which may come into play and something can arise. GGMC has pointed to something arising which would legitimate its decision to change its mind and go back on its promise. And Your Honors, I respectfully believe, and I respectfully urge the court, that on the affidavit of Donald Singh before the learned Chief Justice, those are the only 2 points which are raised, and both are discredited immediately. And therefore, there is no material, there is nothing to suggest that GGMC had any other lawful option in the exercise of its statutory discretion, which was already exercised because they promised to give the allocation to Diamond, to conclude the transaction and issue the license. And therefore, the learned Chief Justice was quite correct to quash the decision to subdivide. The decision is shown in Exhibit C2, to grant the mandamus, and to grant the prohibition. And interestingly enough, Your Honors, I respectfully ask the court to find that the Court of Appeal again looked at the consistent evidence and again said the learned Chief Justice acted entirely properly when he made his findings of fact. And there was no other option but to come to the conclusion Diamond is entitled to the grant of this license based on what has happened. And therefore, I respectfully disagree with the Court of Appeal, having concluded that there's no other option, when they said, nevertheless, we will return it to GGMC for them to decide a decision that's already been made, and in respect of which there's no other lawful option. And I respectfully ask the court to find that the Court of Appeal should not, therefore, have varied the Chief Justice's order of mandamus compelling the issue of the license in favor of Diamond.
Mr. Jonas, maybe you could conclude your geographical tour with page 126, that map, just to conclude that. Maybe it could be put up, because that is the map, as I understand it, with the subdivision, proposed subdivision, or supposed, proposed, or imposed, whatever it is. Maybe the registrar could put up that page 126. I think then we have a complete picture.
I'm very grateful to you, Justice Witt. Thank you very much. At page 126, Your Honors will find a plan that shows a division . Forgive me, I'll wait for it to come up.
You're almost there.
Yes, it's Exhibit U. That is it. Your Honors will find a plan that shows a subdivision of the 1,628 acres, which is to the south of the 2006 1,200 acre application. It's subdivided into a northern portion and a southern portion. Your Honors, Exhibit C2, which is authored by Mr. Singh, speaks to the subdivision into northern portion and southern portion. I did not advert Your Honor's attention to this plan because it may necessitate me introducing evidence from the bar. You see, it is my belief that this plan was submitted by GGMC to delineate where they intended to subdivide northern portion and southern portion. But insofar as this plan appears, the only reference to the plan is by the affidavit of Ashok Rahman, which is at paragraph 62 of his affidavit at page 62 of your record, where he says, Your Honor, I'll just read it to avoid the necessity, please, to travel to that page. I was summoned to a meeting by the GGMC on February 10th, 2015. We're familiar with that, with representatives from Diamond Quarry, Inc., during which the GGMC proposed that the existing lands be subdivided in manner shown in map attached here to and marked as Exhibit U. So Mr. Rahman does not identify who prepared this plan, but he says the GGMC proposed that the subdivision be done in accordance with this plan.
Baraca, the northern portion, is that it? And to give Diamond the southern portion.
That was the decision taken according to Exhibit C2, where it was said in Exhibit C2, this is what we will do. And that is why Diamond went to court. But even so, Your Honors, if you have regard to the occupation survey by the same GGMC, the illegal occupation by Baraca, which they are attaching so much weight to, is a fly speck of 2 acres in the northern corner. Your Honor, 2 acres is 0.1%, 0.1513% of this piece of land.
Towards the south of the northern portion, Mr. Jonas.
No, sir, towards the northwest of the northern portion. The fly speck is the northwest corner. Yes, please.
I hear you, but I'm asking a different question. Towards the southern section there, I see something that looks like buildings. I don't know if the cursor could be. Yeah.
Of the northern portion, sir?
Yeah, the southern section of the northern portion. And I see the letters GGMC 131. There's 47 there as well.
Your Honor, I don't believe we can conclude that those are buildings. Your Honor,
yes, but that's my question. What are those? They look
Your Honor, they could be cliffs, they could be deposits. Your Honor, I don't want to speculate. But Your Honor, we'll see if you have regard to the occupational plan, which I believe is page 83. That buildings are identified on that occupational plan.
Right.
Right. But those buildings do not correspond with the dots that we see at page 126.
Yes, because I'm sure you're aware that the allegation is that Baraca was occupying by reference to several buildings, offices, residences, and so on.
Yes, sir. And if they're trespassing, I believe they do so at their own risk. Whatever infrastructure that happens to exist and however it arrived. And they were acting, their actions were criminal under the Mining Act.
Yes, but you're saying that all of that, in your view, would have been within the roughly 2 acres.
The fly speck, yes, please, sir. And page 83 identifies building.
If you go to your map on page 83, which you showed us, that says that the certain things denote houses, denote water trestles, fuel tank, generator, yes, workshop. So,
and I don't believe they correspond with the undefined dots on page 126.
But those are all buildings at
yes,
the northwestern part of this plot, so to speak.
Yes, please, sir.
Yeah.
According to the occupational plan.
If they are buildings, Tumpy, that's they are illegal, so we don't have to worry about that.
That is my respectful position. Yes, please, sir.
Good. Thank you.
Eddie, you want to say anything? Your Honor, may I hand your honors over to Mr. Loku, who is leading me?
Yes.
If it pleases.
Yeah, we are hearing you, Mr. Loku.
Yeah, Your Honor, I wouldn't tarry you more than a few minutes because my learned friend, Mr. Jonas, has covered the entire geography of the area, but I would feel remiss if I wasn't given the opportunity to speak to this illustrious court, at least for a few minutes. Your Honors, in addition to the reference, I'm dealing with the issue now, Your Honor, that I take issue with the submission by the appellants that the application by Baraca in 2006 was for the same area the Diamond Quarry applied for. And I wish to bring to Your Honor's attention, in addition to the reference made by my learned friend, Mr. Jonas, to the affidavit of Donald Singh on behalf of GGMC, to two references in the affidavit of Ashik Rahman, where Ashik Rahman himself concedes that the application which was made by Baraca was not for the same area as that applied for by Diamond Quarries. And Your Honor, I would not read the paragraphs. I merely would, for the court's utilization, give the references. Page 58 of the record, paragraph 38, where Rahman concedes that there was a mistake made in the application as to the coordinates. And at page 60 of the record, paragraph 50, where he says that Baraca had inadvertently applied for lands north of which it was occupying. Now, if it made an application for a different portion of land or a different area, it could not be an application for the same area. And finally, Your Honor, in that regard, at page 122, there was a letter from Baraca which was written to the Minister of Natural Resources, where he admitted that the application failed to include certain areas which it was intended to include. I just make those references to corroborate the reference to Donald Singh in his affidavit on behalf of GGMC, that the area applied for by Baraca was north of the area which it occupied. Your Honor, the plinth and substance of the appellant's case is based on the application, based on the argument that the application by Baraca was for the same area applied for by Diamond Quarries. If the substrata of that argument is removed, there is nothing, I respectfully submit, left in the appellant's case. If Baraca, Your Honors, did not apply for the same area as Diamond Quarry, and if Baraca is not entitled to a license of the area applied for by Diamond Quarry, and if a promise was indeed made, which is clear from the submissions put forward by my learned friend, which I will not repeat, to Diamond Quarry to grant it a license, it is respectfully submitted that the only lawful exercise of the discretion by GGMC could be to grant Diamond Quarry a license. You see, Your Honor, when GGMC, I'm sorry, Baraca is not with us. When GGMC talks about an overriding interest, that overriding interest they're talking about is premised on an application by Baraca for the same area the Diamond Quarries applied for, which was subsequently discovered. So if Your Honors agree with our submissions that the area applied for by Baraca was not the same area that was applied for by Diamond Quarries, the basis of the overriding interest would no longer subsist. And therefore, the only legitimate exercise of a discretion by GGMC would be to grant the quarry license to Diamond Quarries. Your Honor, that is all I wish to add. I think my learned friend has covered all the geographical areas, and unless the court wishes to ask me anything, I need not tarry you anymore.
Mr. Lakou, I do have one question, because the Court of Appeal more or less put the case back in the hands of GGMC to take the decision, which, if we understand the decision of the Court of Appeal correctly, can only be giving the license to Diamond. But they don't do it themselves. And you said they relied on Camacho, the case of Camacho. And that should not be followed. Could you elaborate a little bit on that? Because there must be some more jurisprudence taking us away from Camacho, as you are suggesting.
Yeah,
so
I'm sorry, Your Honor. Please continue.
Yeah, so the question is, could you elaborate a little bit on that?
Yes, certainly, Your Honor. I think when my learned friend, Mr. Ramkaran, referred to Camacho, he was intending to refer to another case, which was Rutherford, because the cease work order case was not Camacho. Camacho was a case, Your Honor, which was decided in 1970, when the jurisprudence relating to legitimate expectation, and particularly substantive legitimate expectation, had not yet developed. Following Camacho in 1970, the law relating to substantive legitimate expectation has developed considerably. And, Your Honor, I don't think it is even necessary for this court to go back to Coughlin's case, because this court has made pronouncements in two recent cases, one not so recent, Farsalas, and also in Chunilal Babulal more recently, I think it was Justice Anderson, where the development of the law relating to substantive legislation as a jurisprudential tenet of Caribbean law is now firmly established. It wasn't so established at the time of Camacho in 1970. It was still developing. And the development of that law, those laws, Your Honor, is set out in Fordham, which we attach to our submissions at page 841 of the record. I wouldn't read it out, but Fordham very succinctly addresses the development of the law as it relates to legitimate expectation and the development. And, Your Honor, I think it is now crystallized in the jurisprudence of this court in recent decisions. Of course, every case you will have to look at the particular facts. Is there an overriding interest which establishes that the legitimate expectation should be denied? In this case, the overriding fact that's relied on is the subsequent discovery that Baraca had applied for the same area of land, but it has been shown that that isn't so. So the basis of the overriding interest doesn't exist in that case. Your Honor, if I may deal very briefly with Rutherford's case, where the Court of Appeal in Guyana determined that the decision to grant a cease work order was a discretion which was vested in the commission and ought not to be exercised by the court. That was based on the peculiar wording of the section of the paragraph in the regulations which dealt with the cease work orders. And Regulation 98, and I refer to Rutherford, Your Honor, the decision, it is in your bundle of documents, Your Honor. I don't have the reference I have the reference in the case, page 355 of the case. This is what Regulation 98 of the regulations under the Mining Act said. Regulation 98 first demanded of the commissioner or his representative a determination that it was absolutely necessary for the maintenance of public peace or the protection of the interests of the state or private person that a cease work order should issue. In other words, there were specific factors which had to be considered by the Commission before a cease work order was issued. And what the Court of Appeal found in Rutherford's case, Your Honor, in particular, if I can take you down to page 361, and this is what Chancellor Singersey then was said at page 361E. As was earlier pointed out, whether such an order was absolutely necessary was a judgment to be made by the Commissioner. It was inappropriate for the court to issue such a directive. The repository of the power to make that judgment was the Commissioner. That was because, Your Honor, when you deal with the circumstances of a cease work order, there are factors which have to be considered by the Commissioner, that it is absolutely necessary in public interest and safety, which would be based on evidence which would be before the Commissioner and which was not before the Court of Appeal. So I think the Court of Appeal was quite right in the circumstances of a cease work order in Rutherford's case, that they ought not to exercise that discretion because those peculiar facts were not before them. Your Honor, in relation to Comm'r's case, in our submissions in reply on the Court of Appeal, we set out, I think, the reasons why Comm'r should not be followed now. And Your Honor, Comm'r dealt not so much with a legal right, which I think we have established in, as a matter of fact, substantive legitimate expectation, Your Honor, I think has evolved now into more than a discretion. It's almost evolving to legal right if the particular circumstances are before the court. And I think in the context even of Comm'r's case, if it was decided now, the court may well have ordered that the customs license be issued. And our submissions deal with Comm'r's case in, thank you, with Comm'r's case in answer from page at page 406 of Your Honor's records, from page 74. And we deal with why we say that, a bit before that, from page, paragraph 72.
Starts 405, and that's where it's.
Yes, Your Honor. 405, I deal with His Honor Justice Anderson's dicta in GGMC versus BK International Chunilal Babulal. And then we go on to discuss, because I think we needed to discuss Comm'r's case, because it was referred to by the Court of Appeal. And we say that the law has evolved substantially in this regard from 1970 to now. And I think it's a welcome evolution of the law, Your Honor. And I don't think we even need, this court need not even go back to the Coughlin cases of old, because we have now established our own jurisprudential basis in our Caribbean court. Subject, Your Honors, that is all I wish.
Mr. Laku, what is the order that your side is asking this court to make?
Your Honor, we are asking this court to uphold the ruling of the Court of Appeal as regards certiorari and prohibition, and we are asking this court to restore the order of the Chief Justice in relation to mandamus, legitimate expectation having been established in this case, and there being no overriding interest. Public interest was not raised at all by GGMC. The overriding interest is something separate from public interest. But there is no, if Your Honors agree with our submissions that there was no application for the same land by Baraca, there is no overriding interest why legitimate expectation should not be granted in favor of diamond quarries. So we asked the court to restore the order of mandamus. That is our cross appeal. And we asked the court to uphold the Court of Appeal and the learned Chief Justice in relation to orders of certiorari and prohibition.
Yes, very well. Mr. Ramkaran, do you have any submissions in reply?
Your Honor, if you will permit me, just less than 5 minutes, please, Your Honor. Your Honor's reference was made by Mr. Jonas to Exhibit C, and Mr. Jonas asserted from a paragraph on Exhibit C is at page 256, Your Honor. Mr. Jonas asserted that from the first paragraph of Exhibit C on page 257, which starts with the area will be divided into a northern portion which will be granted to Baraca, etc. Mr. Jonas asserted that that was a decision made by GGMC. Your Honor, but on the page before, this is a report by Donald Singh. On the page before, it says that the objective, there was a meeting between GGMC and the parties, and the objective of the meeting was to reach a compromise for the area applied for by both parties. Then the next paragraph, the outcome of the meeting was the representatives agree to a subdivision. And then the part relied on by Mr. Jonas for his submission that this was a decision by GGMC. It states what the subdivision is. So it's
I understand. You're
a bit too far.
You're saying that this is not a determination by the commission, but rather an expression of what was agreed.
Quite, Your Honor. Your Honor, next issue that I just want to attract your attention to is the map at page 126. That map, Your Honor.
Mr. Ramkaran, so is it that GGMC has no intention to impose such a subdivision?
GGMC cannot impose a subdivision, Your Honor. The Act does not allow it to do so. There's no provision in the Act to order subdivision. It can only do so by agreement of the parties.
So it is off the table.
Yes, Your Honor. It is.
Okay.
Either reject or accept the application of diamond quarries, unless the parties decide. Your Honor, there is a submissions which I didn't get to in my arguments, which relate to the evidence of Baraca in the Court of Appeal. Your Honor, in the Court of Appeal, on behalf of Diamond Quarry, this is what was argued, and I set it out at page 846 in paragraph 49, if you'll permit me to read it. That in the Court of Appeal, it was submitted on behalf of Diamond Quarry at page 172 of the record, and I'm reading from page 846. It is respectfully submitted, however, that the permission given to the appellant to file appeal number 61 of 2015 should not be confused with the permission which has not been sought by the appellant or given by the court to adduce new evidence before the court. So the question is the status of the evidence advanced by Baraca. According to Mr. Jonas's evidence, the basis of Mr. Jonas's evidence is that Mr. Jonas's argument is that the evidence before the Court of Appeal is acceptable in relation to the merits of the argument. Your Honor, that evidence by Baraca, nobody has had a chance to reply to it. GGMC has not had a chance to reply to it. And the Court of Appeal is a court of rehearing under Section 3, I think, of the Court of Appeal Act. So I don't know where we are going with this evidence led by Baraca. It's either evidence, we either restrict it to evidence which is to enable the Court of Appeal to make a determination as to whether the matter is to go back to the lower court. Your Honor, in my own submissions to the Court of Appeal, in the first 5 paragraphs, I submitted to the Court of Appeal that in relation to Baraca, if it agrees, if it accepts the argument of Baraca, it should then remit the matter to the High Court for rehearing with Baraca as a party. I argued that in the Court of Appeal, but the Court of Appeal didn't do so, and then proceeded to hear the case, accepting the evidence of Baraca on the merits. So the question of the status of that evidence is open, and Mr. Loku argued that that evidence is not admissible. It's not admissible. I presume it's only admissible for the purposes of determining whether Baraca should be a party. And that is the evidence now relied on by Mr. Jonas for the in support of his case. Your Honors, finally, there's the issue of the land, which the map at page 126. Your Honor, that map, I think, is probably the most accurate of all the maps. It shows the area occupied by Baraca. It shows the proposed division of the land that we intend. Your Honor, finally, I apologize for making a mistake with the case. I intended to refer, as Mr. Loku correctly pointed out, I intended to refer to the case of Rutherford. Rutherford is the case, and Mr. Loku explained it quite adequately, is the case which the mandamus was set aside, the order of mandamus was set aside, and it was referred to by the Court of Appeal for GGMC to make a decision in relation to the cease work order. And GGMC has a discretion here too. It had a discretion on the 98, Regulation 98 for the cease work order. It has a regulation on the 88-1 for the issuing of the quarry license. Thank you, Your Honors. That is all.
Okay, yeah, well, thank you very much, Mr. Ramkran, and thank you to all counsel.
Your Honors.
Yes, Mr. Jonas.
Mr. Ramkran has raised an issue which he did not deal with in his opening addresses, namely the affidavit evidence of Baraca and its use by the Court of Appeal, and seems to protest against our reference to that information. I respectfully disagree with him, but given that he had not raised it, we didn't raise it in our answer. He's raised it for the first time in his reply, and I wonder if the court wishes to hear further on that.
2 minutes.
Or
2 minutes.
I don't propose to take more than a few minutes.
2, I said.
I'm very sorry, Your Honor. My volume was off. I didn't hear you.
No, I said go ahead. I'll give you 2 minutes.
Yeah, let me take a 20-second deep breath. The power of the Court of Appeal, as my learned friend correctly points out, is as a court of rehearing to review what happened below. And in the exercise of that power, as my friend points out, Section 6 of the Court of Appeal Act being relevant, the Court of Appeal is empowered to take in new evidence, whether it's viva voce affidavit evidence. Section 6 of the Court of Appeal Act permits that to do justice. So when Baraca applied by way of notice of motion, and the application is set out at page 45 of your record, asking for an order that it be added as a party and to fully participate in the hearing of the appeal, and produced a lengthy affidavit in support. The function of the Court of Appeal in deciding whether to hear Baraca, admit them as a party, and what consequential orders ought to be made having heard Baraca, turn on whether any new evidence introduced by Baraca lends toward impugning the correctness of the decision of the learned Chief Justice. So the Court of Appeal received the application by Baraca to be joined, looked at the lengthy affidavit by its principal, Mr. Rahman, and decided that the affidavit by Mr. Rahman did not introduce any information, any new evidence upon which the argument can be based that the decision of Justice Chang at first instance should be impugned. So the Court of Appeal correctly exercises discretion and its power under the Court of Appeal Act over my protests. And in its decision, which is before your honors, at pages 13 going forward, specifically refers to and looks at and discusses and rejects and accepts the affidavit evidence of Baraca, coming to the conclusion properly that at page 10, Baraca did not make any application for the license. And specifically, please, your honors, at paragraph 15, which is at page 18 of your record, we found specifically whether or not there was a license given to Baraca for the land in question, what area of land Baraca was actually occupying, and whether or not a license was actually applied for in relation to those areas. It would seem, based on the arguments of counsel for the intervener, that is Mr. Kisoon, that Baraca Quarries being on the land for in excess of 50 years, he seems to be making a mistake in relation to what is occupied and what is actually applied for. Your Honor, Baraca's new evidence was heard, was considered by the court, and the court came to the conclusion that the findings of fact by the learned Chief Justice at first instance were vindicated. So what new material was there before the Court of Appeal to permit any inference impugning the decision of Justice Chang so as to remit the matter for rehearing at first instance? That is the only way the Court of Appeal could properly have done that, is if the new information introduced
Mr. Jonas, was there any ground of appeal by the other side, by the GGMC, against using this evidence?
Your Honor, you've taken me by surprise, and of course...
Well, it's a logical question.
It certainly is, Your Honor. Please just give me 1 minute to find that. And that's, you know... Yeah. Please. Your Honors, I do not see at pages 2 or 3 any protest against the use by the Court of Appeal of the affidavit of Baraca. Considering that Baraca was on the same side as GGMC, I would be surprised if there was any such. But I do not see a protest as a ground of appeal to this court, that the Court of Appeal did anything wrong when it made reference to the affidavit evidence by Baraca.
So that could be the short answer to the question.
Your Honor, you've stolen my thunder. I will leave it alone. Thank you.
Yes, well, thank you very much again, Counsel. We will take time for our decision in this matter, and we will certainly let you know as soon as we're able to give that decision.
Very grateful, Your Honor.
Yes.
Thank you.
Quickly, Your Honor.
Yes, Ms. Thomas Roberts, would you please close the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnapli. Thank you, Mr. Justice Burgess. Thank you, Counsel. Thank you to the staff of the Caribbean Court of Justice, especially our registrar for her assistance today. This court now stands adjourned. Good day to all. Thank you.
Thank you. Good day.